You seem a little intoxicated to me, Diana. I'm a little concerned about how much that you've had to drink. What is it that you're under the influence of right now?
Maybe I had vodka tonight.
Vodka?
Yeah.
How much vodka did you have?
Just one.
On July 19, 2025, officers responded to a report of a hit-and-run in a Cleveland area neighborhood. What began as a routine fender-bender call quickly evolved into something far more serious. Multiple civilian witnesses had already blocked in the suspect vehicle. They recorded video. They stayed on scene. And they told a story that the driver could not or would not contradict. This is that body cam footage. And this is what the law says about what happened next. Officers arrived to find two civilian witnesses waiting, both of whom had been present at the initial collision at 27th Avenue and 16th Street. One witness had recorded video of the suspect vehicle being blocked in by multiple cars after a series of bumps. The other lived 2 blocks away, heard the impact against a guardrail, and ran out in time to see the suspect vehicle extract itself and flee. Both witnesses remained on scene, provided statements, and offered to share digital evidence, phone footage, and dashcam recordings. The sequence of events described by the witnesses was consistent and corroborated. The suspect vehicle struck at least one car, was temporarily boxed in by bystanders, and then forced its way through a gap when one of the blocking vehicles moved. The driver then made a sharp left turn, struck a guardrail hard enough to damage it and be heard from 2 blocks away, and reversed before continuing down the road, leaking fluid to her home driveway. Under Ohio Revised Code Section 4549.02, a driver involved in a collision is legally required to stop at or near the scene, provide their name and vehicle information to the other party, and render reasonable assistance. Diana did none of these things. Instead, she drove away after striking at least one civilian vehicle. That decision to leave transformed a civil traffic matter into a criminal hit-and-run investigation before officers had even spoken to her. With witness statements secured and video evidence in hand, officers turned their attention to Diana, who had retreated to her home address. Her vehicle was already in the driveway. Officers could observe, without entering the property, visible damage to the front end of the car and fluid actively pooling beneath it, consistent with the guardrail impact and collision described by witnesses. This observation is legally significant. Under the plain view doctrine, officers may note evidence in plain sight without a warrant. Officer contact with Diana begins at the door. She states only a dog is inside. The officer immediately begins what he will later formally designate as the civil crash investigation, a legally distinct phase designed to gather information about the accident itself, separate from any criminal inquiry. This distinction matters. Statements made during a non-custodial civil crash investigation are generally admissible, though the boundaries can become legally complex when the same officer later transitions to criminal charges. Diana's explanation for leaving the scene is immediately inconsistent. She claims she stopped before returning home. When asked why she left without exchanging information, she offers a story that another woman at the scene told her to return to her driveway, a claim the officer correctly identifies as logically incoherent. How would a stranger at an accident scene know where Diana lives? The officer notes, for the record, that Diana is visibly unsteady on her feet. This observation begins building the basis for the DUI investigation that is about to follow. Diana's timeline immediately collapses under basic questioning. She first claims to have worked a 7 to 7 shift, which would have ended at 7 in the evening. When the officer points out that the current time contradicts this, she revises to a 10 to 10 shift. She then provides an explanation for leaving early. She was vomiting and feeling ill. For an officer trained to identify signs of intoxication, a shifting timeline, physical unsteadiness, and a self-reported illness before driving are all consistent with impairment indicators under NHTSA DUI detection protocols.
You seem a little intoxicated to me, Diana. I'm a little concerned about how much that you've had to drink. What is it that you're under the influence of right now?
Maybe I had vodka tonight.
Vodka?
Yeah.
How much vodka did you have?
Just one.
When pressed on the timing of her alcohol consumption,
10 o'clock?
Diana's
Oh, you're
story
at work?
shifts again. She first says
so-
she had vodka at 10 o'clock. The officer correctly
had it
notes
at
that if she
10
worked from
a.m.
10 in the morning,
before you went to
drinking
work
at
at 7
10
a.m.
before her shift would mean
That doesn't
drinking
make sense.
immediately before going to work at a hospital. Diana then changes her
you said
account.
7 to
She had it
7.
at 8 in the morning, she says,
Okay,
which
so
would have
your
been
shift
roughly
is from
90
10
minutes
a.m.
before
to 10
clocking in at
p.m. And just before
9:44.
going
Her
into
clock-in
work,
time
you
is
had
later
a double
confirmed
shot of
during the
vodka,
investigation.
which is probably
Under Ohio
why you
Revised
got
Code
sent
Section
home.
4511.19, a person commits the offense of operating a vehicle while impaired, commonly called OVI, when they operate a motor vehicle while under the influence of alcohol, a drug of abuse, or a combination of both. Crucially, Ohio law does not require proof of a specific blood alcohol content level. Observable impairment, difficulty standing, incoherent statements, and an admission of alcohol consumption is independently sufficient to establish probable cause for arrest. The officer probes further.
Lorazepam is for anxiety.
On the floor of Diana's
So
vehicle
you-
lies a
what time did you
prescription
take your
bottle.
lorazepam?
She acknowledges taking 2 medications, Adderall, prescribed for ADHD,
What were you doing
and
at
lorazepam,
4:30 up at
a
4:30 in the morning?
benzodiazepine, commonly known
wake up
as
at 4 so you
Ativan,
could go
prescribed
to
for
work at 10.
anxiety.
Okay.
She states she
And
took
what
both at
about
approximately
the
4:30
Adderall?
in the
What time did you
morning.
take your
The
Adderall?
combination of
At
these
4
facts
o'clock in the
creates a
morning?
compounding
And then
impairment
just
picture.
before 10 a.m. Did you show up to work on
Lorazepam
time
is a
today?
central nervous system
And who
depressant.
did you check in with
Mixing
when
it
you
with
went to work?
alcohol dramatically amplifies
You have,
sedative
like, a time
effects.
clock or something?
Adderall, a stimulant, can mask the
And when you
subjective
clocked in,
feeling of
what time was it?
intoxication, meaning a person
10
may
a.m.?
feel more alert than they are, yet remain critically impaired.
What's going on that you're taking double shots of vodka at 8 o'clock in the morning?
Like I'm depressed.
Okay.
This pharmacological combination is recognized by the National Highway Traffic Safety Administration as a drug category associated with DUI impairment independent of alcohol. Ohio Revised Code Section 4511.19 specifically covers impairment by a drug of abuse, and Ohio courts have recognized that prescription medications, when combined with alcohol or taken in a manner that causes impairment, meet this standard. The lead officer delivers a calm but legally precise summary of the situation. He is not accusing, he is documenting. He enumerates the prescription medications, the alcohol, the vehicle crash, the flight from scene, the guardrail collision, the second witness who observed the impacts. He notes Diana's pants are on backwards, a detail that, while small, is consistent with significant disorientation at the time of dressing, further supporting the impairment timeline. Throughout this exchange, Diana sways visibly.
So right now, you have the right to remain silent. Anything you say can be used against you in a court of law. You have the right to talk to a lawyer and have him present while you are being questioned. If you cannot afford to hire a lawyer, one will be appointed to represent you before any questioning if you wish one. Okay? Do you understand these rights have I read to you? If you don't understand them, do you want me to read them to you again?
The officer's explicit designation of the criminal investigation phase reflects a dual-track protocol that is legally sound and tactically important. In Berkemer versus McCarty, the Supreme Court established that ordinary traffic stops do not trigger Miranda protections because they are brief and non-custodial. However, once a detention becomes custodial, meaning a reasonable person would not feel free to leave, Miranda applies by formally separating the crash inquiry from the criminal DUI inquiry and reading Miranda rights before questioning Diana about drinking. The officer helps insulate the subsequent statements from Fifth Amendment suppression challenges. Before beginning the standardized field sobriety examination, the officer diligently establishes Diana's medical baseline. Consistent with NHTSA FST protocols, he asks about corrective lenses, physical impairments, footwear comfort, and medications. He confirms Diana takes medication for hypertension, last taken at 9:09 that morning. This pretest intake is not a formality. It is legally essential. Defense attorneys routinely challenge FST results on grounds that physical conditions, not impairment, caused poor performance. A thorough baseline inquiry closes that door. The horizontal gaze nystagmus test, the most scientifically validated of the 3 standardized FSTs, requires the subject to follow a moving stimulus with their eyes, while holding their head still. Diana cannot comply with the foundational instruction, feet together, hands at
With your
sides,
and your
eyes
only,
tracking the
follow
pen.
the tip
She
of the
moves
pen,
her head,
okay? You
steps
understand what
out
tip
of
the pen is?
position,
Can you touch the tip of
and
the pen with your
ultimately
finger?
acknowledges she does not think
Okay.
she can
Follow the
complete
tip of
the
the pen,
task.
okay?
While the HGN results are not verbally reported in this footage, Diana's inability to follow basic instructions is itself an independent indicator of impairment documented on camera. The walk and turn test requires the subject to maintain a heel-to-toe stance on a designated line during instructions. Before walking begins, Diana cannot do so. Despite clear demonstration by the officer and multiple patient corrections, she is unable to hold the starting position. The test is discontinued before Diana takes a single step. Under NHTSA guidelines, inability to maintain the instructional stance is itself a scored clue of impairment. Diana does not appear to fully absorb the Miranda advisement on the first reading. She protests, still seeking to explain herself. Her partner officer notes, matter-of-factly, that there is nothing wrong with telling her she is under arrest. The lead officer, preferring to give Diana the chance to hear and acknowledge her rights, reads them a second time before asking any further questions. This redundant advisement, while unusual, eliminates any future claim that Diana was not adequately informed of her constitutional rights before making incriminating statements. Post-Miranda, the questioning resumes. Diana now says she had 2 double shots of vodka, an escalation from the single shot admitted earlier. She says she purchased them at a Walgreens. When asked again what time she got off work, she says 12, then 11, then revises back to 10. The officer documents each version. These are not minor inconsistencies. For a jury evaluating credibility, a subject who cannot maintain a consistent account of when she finished her shift, how much she drank, or what time she drank it, is not a credible narrator of any part of the day's events. Diana's final line of defense is a denial that she was driving at all. This defense is foreclosed by the evidence. 2 witnesses independently identified her as the driver. One filmed her behind the wheel. Her vehicle is in her driveway, damaged, leaking fluid, consistent with the collision sequence described by both witnesses. The officer states clearly that witnesses exist to place her at the wheel. The arrest proceeds. What began as a series of vehicle impacts in a residential neighborhood concluded with a DUI arrest supported by physical evidence, multiple corroborating witnesses, a damaged guardrail, a leaking vehicle, contradictory statements, visible impairment indicators, and an admission of alcohol consumption before driving. The question remaining for the legal system: what charges were filed, and what was the outcome? At the time of this analysis, the outcome of criminal proceedings against Diana remains unknown. No publicly accessible court records, news reports, or official statements confirming charges, plea agreements, or verdicts were located. Based on the evidence documented in this footage alone, however, charges of operating a vehicle while impaired under Ohio Revised Code Section 4511.19 and failure to stop after accident under Section 4549.02 appear legally sustainable. If chemical testing confirmed a blood alcohol content consistent with impairment, or if a drug recognition expert evaluated Diana, additional charges under Ohio's drug OVI provision may also apply. The lead officer in this footage receives an A-. His handling of this investigation demonstrated procedural precision that is uncommon in real-world field conditions. He correctly bifurcated the crash investigation from the criminal DUI inquiry, administered Miranda rights twice to ensure comprehension, followed NHTSA field sobriety protocols with patience and thoroughness, and maintained a calm, empathetic tone with a subject who was clearly distressed and struggling. His verbal documentation of observable impairment indicators directly into the Bodycam record reflects training and professionalism. The grade stops short of an A because the Miranda advisement was initially read before the subject appeared ready to absorb it, requiring a repeat. A brief pause to secure Diana's attention before the first reading would have been procedurally cleaner. Nonetheless, this is an example of how to conduct a sensitive, dual-track DUI investigation with both legal precision and human decency. Diana receives a C+. The grade reflects not a moral judgment, but an assessment of decision-making in the context of rights, responsibilities, and legal exposure. Diana made several choices that compounded her legal jeopardy. She admitted to alcohol consumption without invoking her Fifth Amendment right to silence, provided multiple contradictory accounts of her timeline, agreed to field sobriety testing without consulting an attorney, and denied driving at a point where witness testimony and physical evidence made the denial unsustainable. On the positive side, Diana did not physically resist arrest, did not attempt to flee again, and ultimately acknowledged the gravity of the situation. Her mention of depression, while not a legal defense, is a human detail that the legal system should consider in any sentencing context. The C+ reflects a citizen who, in a very difficult moment, did not make the situation better, but who also did not escalate it further. Before we go, here are a few takeaways from this case. 1. In Ohio, OVI does not require a specific BAC reading. Observable impairment, confirmed by officer testimony, witness accounts, and FST failure, is legally sufficient on its own. 2. Prescription medications can support an OVI charge, even without alcohol, if they cause impairment, mixing them with alcohol compounds both the danger and the legal exposure. 3. Field sobriety tests are voluntary, but declining or performing poorly still enters the Bodycam record and can be considered evidence. 4. When officers formally separate a crash investigation from a criminal DUI investigation, statements made during the civil phase may still appear in the criminal record. Understand which hat an officer is wearing before speaking. 5. If you are involved in a traffic collision, stop. Leaving the scene converts a civil matter into a criminal one, regardless of the severity of the original impact. Let us know if there is an interaction or legal topic that you would like us to discuss in the comments below. If you found this analysis useful, make sure to subscribe and hit the notification bell so you don't miss our next case breakdown. Thank you for watching.